Hello.
Hello, sir. Hello, sir. Namaskar. Good evening, sir. Good evening, sir.
Good evening. Good
I am myself,
Good evening.
Dr. Nataraj, principal from JSS Law College, faculty and all over.
Good.
Welcome to JSS Law College, sir.
Yeah, good to see you all. Great.
Thank you, sir.
Okay, you tell me when to start.
Yes, sir. So, with your permission, shall we begin the event?
Beg your pardon?
With your permission, shall we begin the event?
With your permission.
Oh, yeah.
With your
Yes.
Yeah.
Oh.
Yes.
Good evening, everybody. My name is Jhalak Darla, and I will be the host for the day. I would like to welcome everyone to the NEETI talks on the Doctrine of Basic Structure by Shri Fali Sam Nariman, sir, Senior Advocate, Supreme Court of India, and former Member of Parliament, Rajya Sabha. Welcome, sir. The NEETI Forum, where experience speaks, is a knowledge-based initiative which will serve the participants with efficient and accessible means of administration. Let's start by reviewing today's agenda. We will begin with the introduction of the guest speaker, who undeniably does not require any kind of introduction, yet will be given by Ms. Navya. Following the introduction, Shri Fali Sam Nariman, sir, will be addressing the gathering with his valuable diction. Simultaneously, the participants can raise questions. The questions will have to be typed in the chat box, from where Ms. Shashwati will take it forward. Mr. Antriksh will then be called upon to render the vote of thanks. I now request Dr. S. Nataraju, sir, our esteemed principal of JSS Law College Autonomous, to give a welcome to the distinguished speaker for the day.
Hello, namaskara. Good evening, everybody. Respected distinguished speaker of the day, Shri F.S. Nariman, sir, faculty members, students, and all other invitees. At the outset, I express my respectful pranams to Shri Siddhur Guru Parampara and seeking the blessings of His Holiness Jagadguru, Shri Shivaratri Deshikendra Mahaswamiji Gavaru, the present pontiff and the president of JSS Mahavidyapita, Mysore. JSS Law College is an autonomous law college, is functioning under the aegis of JSS Mahavidyapita. It was established in the year 1952. We have more than 350 institutions starting from kindergarten to PG, research institute, including 2 universities. Our law college has started in the year 1982. It is the first autonomous law college in the country. The college has been recognized by the UGC as a college with potential for excellence and as accredited by the NAC. Since its inception, it is striving to search for innovative methods, implementing quality legal education, and attract students from all over the country and also from abroad. We have organized this program under the banner of JSS Law College NEETI Forum. It is constituted as a part of IKC initiatives of the college, with the objectives to have a knowledge-based initiative to serve the students and faculty by efficient and accessible administration of knowledge for all. We have started this NEETI Forum in the year 2021. It was inaugurated by Honorable Justice Mr. Puriya Joseph, former Judge of Supreme Court of India, subsequently distinguished speaker who have delivered talk on various topics. To quote few, Justice Mr. Chalameshwar on the topic rule of law, Justice Shri K.T. Thomas on secularism, Justice Shri A.K. Ganguly on public interest litigation, like many other distinguished judges of Supreme Court and High Court, addresses on various contemporary legal issues. Now I take this opportunity and I consider it a privilege to introduce and welcome distinguished legal luminary and senior advocate of Supreme Court of India, Shri Fali Sam Nariman, sir, former member of Rajya Sabha, who is going to deliver a lecture on the doctrine of basic structure, which is derived in the famous case Keshavananda Bharati versus State of Kerala. Mr. Fali Sam Nariman, sir, has rich experience in a wide range of legal domains, popular in India and abroad, a leading senior advocate of Supreme Court of India, consistently showcasing his versatility and profound understanding of complex legal issues. The details of the contribution of Shri F.S. Nariman, sir, and cases he appeared before the Supreme Court and High Court and other fora, and his achievements will be briefed shortly by Ms. Shri. Sir has kind enough to accept our invitation and is going to address our students and our faculty. I consider it a landmark event in the history of JSS NEETI Forum. Sir, on behalf of JSS Law College, faculty and students, and on my behalf of all the participants, I extend a hearty welcome to you, sir. I also extend a warm welcome to our Chief Executive of our college, Professor K. Suresh, who is guiding us in all of our academic and other activities of the college. I extend a hearty welcome to you, sir. I also extend a hearty welcome to all our faculty members, members of the NEETI forum, students, and all other invitees. Once again, I extend a warm welcome to one and all. Thank you.
Right. Thank you. Thank you, Mr. Natarajan.
Thank you, sir.
Mr. Natarajan, members of the faculty of the Law College of Mysore, I address you all, teachers and pupils, as fellow students. Because a lawyer, as well as a law teacher or professor, is always a student all his or her life. One rule that you must all remember is that the adventure we call life is like riding a bicycle. In order not to fall off, it is essential at all times to keep moving. In life also, especially for life in the law, you must always keep moving, both in body and in mind. And it is the only way to success and achievement. There is just no other way. Dedication to hard work, more and more reading, with more and more time spent on reflection, and less reliance on your mobile phone will help you prosper in the law. Nothing else will. But enough of paternal advice. Let me express my views on the topic chosen by the NEETI forum, the organizers of this lecture. And let me begin at the beginning. In the first 20-odd years of the promulgation of our constitution, India's Supreme Court was faced with a dilemma. And the dilemma was this: the higher judiciary, both the Supreme Court as well as the high courts in the states, are empowered under India's constitution by reason of Article 13(1) and 13(2) to invalidate not only executive orders, but also legislative enactments that violate any part of the fundamental rights guaranteed in Part 3 of the Constitution. But as to whether these courts are also empowered to adjudicate on the validity of constitutional amendments passed with the requisite special majority, even where the procedure prescribed in Article 368 has been scrupulously followed, was something on which the Constitution of India has been and was silent. With one single political party, the Congress Party, consistently returned to power at each general election since 1952 and returned with a thumping 2/3 majority, at least up to 1989. The judges of our Supreme Court kept plumbing the depths of silence in the world's longest constitution, searching for some limitation on the amending power. They did not find it at first. Much later, when they did find it, and how they did, is reflected in subsequent parts of my lecture. I now come to part 1 of the lecture. Prior to and particularly after 26 January 1950, legislatures in India's states passed agrarian reform laws abolishing zamindaris, which was for many ordinary citizens the bane of both Mughal and British Raj in India. A zamindar was the holder of a very large estate or jagir, a landed proprietor. Under the Mughal administration of India, he was a hereditary owner and responsible for the collection of revenue on behalf of the government. When the British East India Company conquered large parts of India, it was to their advantage to continue with the zamindari system. But it left the cultivator of the land with little or no benefit. Zamindari abolition acts that were passed, therefore, came to be challenged in writ petitions filed in high courts under Article 226 of the Constitution on the ground that they contravene the fundamental rights conferred by Part 3 of the Constitution, particularly the fundamental right to property. You will all recall that Article 19(1)(d) and Article 31 had once formed an integral part of India's Constitution as enacted. And these articles were deleted only in the year 1978 by the Constitution 44th Amendment. So between 1950 and 1978, Articles 19(1)(f) and 31 did guarantee the zamindars the right to insist that property acquired by the state could only be so acquired, not only for a public purpose, but also on payment of compensation. And the phrase compensation meant, according to the Supreme Court, following US Supreme Court judgments, it was a just equivalent sum of money, which for the government at that time could hardly afford. The High Court of Patna had held that the Bihar Abolition of Zamindari Act 1950 was unconstitutional, since the taking of zamindari estates was not for a just equivalent and was therefore contrary to Article 31 of the Constitution. But the High Courts of Allahabad and Nagpur had upheld the validity of corresponding abolition of zamindari laws enacted by the states of Uttar Pradesh and Madhya Pradesh. However, the challenge to these laws was still pending in India's Supreme Court. So to put an end to all this litigation and to remedy what the Union government at that time considered to be certain defects brought to light in the working of the Constitution, the Constitution First Amendment Bill 1951 was introduced and got passed with an overwhelming majority of India's provisional parliament, which, as you all know, had also functioned before November 1949 as India's Constituent Assembly for drafting India's Constitution. The Constitution First Amendment Act 1951 introduced Articles 31A and 31B. Article 31A protected land and reform laws from attack under Article 14 as well as Articles 19(1)(f) and 31. And Article 31 capital B was also introduced and passed as an all-embracing exception to the entire chapter on fundamental rights. The validating clause, Article 31B, had authorized the mere placing by Parliament of central and state laws in a newly added schedule, known as the 9th schedule, to be above the Constitution and to be also beyond judicial review of courts. Reacting to the addition of Articles 31A and 31B, namely laws placed in the 9th schedule, the zamindars, that is the landlords of these vast tracts of land in different parts of India, filed petition upon petition in the Supreme Court under Article 32, challenging the provisions of the Constitution First Amendment Act as being unconstitutional and void. Under India's Constitution as enacted in January 1950, as you all know or should know, there were only 7 judges in India's Supreme Court, along with the Chief Justice of India. And it was a bench of 5 justices, popularly known as a Constitution bench, presided over by India's first Chief Justice, Sir Harilal Kanya, who found little difficulty in deciding the constitutional validity of zamindari abolition laws. In a brief but unanimous judgment in Shankari Prasad versus Union of India, they held that, and I quote, to make a law which contravenes the Constitution constitutionally valid is a matter of constitutional amendment and as such falls within the exclusive power of Parliament, unquote. All the petitions filed by a large number of zamindars were consequently dismissed. Almost 15 years passed, and this is a useful lesson for all of you to remember. As written constitutions grow in age, those whose duty it is to interpret them get wiser over time and are also more circumspect. Almost 15 years after Shankari Prasad, 1951, several writ petitions, including one titled Sajan Singh versus State of Rajasthan, were filed challenging on this occasion the constitutional validity of the Constitution 17th Amendment Act 1965. This act, pursuant to the enabling provisions of Article 31 capital B, which had already been included in 1951 in the Constitution, placed even more state laws in the 9th schedule in order to make these laws valid even if they contravene the provision of the Fundamental Rights chapter, including the right to equality and the fundamental right to property. In Sajan Singh versus State of Rajasthan, once again, a constitution bench of 5 justices, this time Chief Justice P.V. Gajendra Khatka presiding, dismissed all the writ petitions, but not quite the same way or with the same certainty as had been done in 1951. Because in Sajan Singh versus State of Rajasthan, only 3 out of the 5 judges on the bench, Chief Justice Gajendra Khatka, Justices Vanchu and Raghubhai Dahar, held that the power of amendment was plenary and included the power to take away or amend all or any of the fundamental rights guaranteed in Part 3 of the Constitution. But, and this is where the growing wiser with age comes in, 2 of the justices on the bench were not so sure, although they agreed that the petitions deserved to be dismissed, but only on the ground of the earlier 1951 Constitution Bench decision of the court in Shankari Prasad, and not for any other reason. And these 2 justices also gave reasons for their doubts, which in turn enabled future judges to ponder over. Justice Hidayatullah had said, the Constitution gives so many assurances in Part 3 that it would be difficult to think that they were the playthings of a special majority. The other judge, Justice Mudolkar, said he would prefer to reserve his opinion as to whether the previous decision in Shankari Prasad was right. And he added, I do not regard what this court has held in that case as the last word. Justice Mudolkar also went on to say that so long as the preamble of the Constitution stood unamended, it would have to be considered whether the power to amend could be exercised with respect to any of what he then called the basic features of the Constitution. Mark the words, basic features of the Constitution. In retrospect, Justice Mudolkar, way back in 1965, was the first judge of India's Supreme Court who appeared to have an inkling or a premonition of what later became known as the basic structure doctrine. And in this wild world of cross-fertilization of our ideas, do you know from where he got the idea from? It was from a decision of Chief Justice Cornelius of the Supreme Court of Pakistan, a decision reported in 1963 PLD 486. At that time, Pakistan, like India, had a Westminster-type constitution. The first constitution of Pakistan was of the year 1956. And Justice Mudolkar acknowledged that he got the idea of basic features from Pakistan's Supreme Court, because this is what he said in his separate judgment in Sajan Singh. And I quote, it would be of interest to mention that the Supreme Court of Pakistan has, in Fazl Qadar Chowdhury versus Muhammad Abdul Haq, 1963 PLD 486 held that franchise and form of government are fundamental features of a constitution, and the power conferred upon the president by the Constitution of Pakistan to remove difficulties does not extend to making an alteration in a fundamental feature of the Constitution. For striking down the action of the president under what he called sub-constitutional power, Chief Justice Cornelius relied on the judge's oath of office, unquote. Something else also happened in the year 1965, which you all must know. Something else that is now relevant, unknown to Justice Mudalkar or Justice Hidayatullah. A certain German jurist, a man called Dietrich Conrad, was on a visit to the Banaras Hindu University in Varanasi. He delivered a lecture to the students in the Banaras Hindu University at Varanasi. Dietrich Conrad was a German scholar who had lived in Germany during the Weimar Constitution that had been adopted after the First World War, and had witnessed how Adolf Hitler climbed to power on the basis of some of the articles of the ill-fated Weimar Constitution. In the course of his lecture, the students of the Banaras Hindu University, Dietrich Conrad gave an insight of what later, much later, came to be known as the basic structure doctrine. And he said so on general principles long before Keshavananda 1973 was even thought of. And please listen to what he had said, and I quote, "Any abending body organized within a statutory scheme, howsoever verbally unlimited its power, cannot by its very structure change the fundamental pillars supporting the constitutional authority. The amending procedure is concerned with the statutory framework of which it forms part itself. It may affect changes in detail, remold the legal expression of underlying principles, adapt the system to the needs of changing conditions, but should not touch the foundations." This entire lecture was later reproduced in a paper titled "Limitation of Amendment Procedures and the Constituent Power" by D. Conrad, and you will find it published under the auspices of the Indian Yearbook of International Affairs, 1966-67, at pages 375 to 430. I now come to part 2 of my lecture, which records an apparently unconnected, but what has become and had become an extremely significant event. Justice K. Subbarao, who had been first appointed judge of the Supreme Court in the year 1958, assumed office as Chief Justice of India in the year 1966. Now, Justice Subbarao was a man who always wore his heart on his sleeve. As judge, he had consistently said that it was an oxymoron to say that fundamental rights could ever be taken away or abridged. How could anything described as fundamental in the Constitution be ever taken away or abridged by an amendment to it? He had often queried. Aware of all this, citizens of India were then emboldened to file, once again, writ petitions challenging the validity of the Constitution First Amendment Act 1951, which had introduced Article 31A and 31B in the Constitution. And they took the opportunity of also challenging, meanwhile, the Constitution Fourth Amendment Act of 1955 that amended Article 31A and added more central and state acts in the 9th schedule, as well as the provisions of the Constitution 17th Amendment Act 1964 that had by then added as many as 43 more central and state laws in the 9th schedule. The principal writ petition filed under Article 32 was titled Golaknath versus State of Punjab. When presented to a bench presided over by Chief Justice Suvarao, it was straightaway admitted and referred to a larger bench of 11 judges for final disposal. Golaknath versus State of Punjab was decided by a bench of 11 judges in 1967. 11 judges presided over by Chief Justice Suvarao. The court held that there was nothing in the Constitution that prevented the Supreme Court from departing from its previous smaller bench decisions of its own, if it was satisfied of its error and the baneful effect on the general interest of the public. It also held, but this it was held by a very narrow majority, 6:5, that an amendment of the Constitution, said 6 judges, was law within the meaning of Article 13 of the Constitution. And if a law, including an amendment to the Constitution, took away or abridged the rights conferred by Part 3 or any part thereof, it was equally void by reason of the provision already contained in Article 13(2) of the Constitution. In Golaknath, a majority of 6 judges in a bench of 11 denied to Parliament what the minority of 5 judges conceded to Parliament, namely the right to take away or abridge in the future any of the fundamental rights in Part 3 of the Constitution. Since according to the majority, because and only because amending the Constitution by an act of Parliament in its constituent capacity was also law under Article 13. But at the same time, and apparently quite inconsistently, all 11 judges upheld and did not strike down, upheld the constitutional validity of the Constitution First Amendment Act 51, the Constitution Fourth Amendment Act of 55, and the Constitution 17th Amendment Act of 1964, 17th. Even though, according to the majority of justices, 6-5, these enactments abridged fundamental rights. Why? Only because of yet another doctrine newly introduced in India, a doctrine then popular in the United States, the doctrine that is known as the doctrine of prospective overruling, a doctrine borrowed from American jurisprudence. This was a doctrine that held that whilst overruling a previous decision, it was discretionary for the court not to undo what had already been done in the past. I now come to part 3 of the lecture. At first, the reaction in Parliament to the majority decision in Golaknath, 1967, was one of surprise. Only a couple of years later, the Supreme Court of India, in the Privy Purse case was decided in 1970. A bench decision also of 11 judges, 10-1. They had struck down as invalid a presidential order passed under Article 362 of the Constitution. That was an article that set out rights and privileges of rulers of Indian states. This presidential order passed under Article 362 abolished all the titles of erstwhile princes of former Indian states together with their privy purses. And Mrs. Gandhi, then Prime Minister, took great umbrage at this decision and advised the President, somewhat in pique, to dissolve the 4th Lok Sabha and call general elections. And in the elections of March 1971, Mrs. Gandhi and her Congress party came back to power with an even larger majority than before. So the mood of the newly constituted parliament changed from one of surprise in 1967 to one of defiance in 1971. Because in its delayed response to the Supreme Court's majority decision of 1967 in Golaknath, India's newly elected parliament now passed in quick succession the following laws, further amending the Constitution. 1. the Constitution 24th Amendment Act 1971, an act to enable Parliament in its constituent power to amend all and any part of the Constitution, including the chapter relating to fundamental rights, and also providing that nothing in Article 13 shall apply to any amendment of the Constitution. Second, the Constitution 25th Amendment Act 1971, which introduced for the first time, Article 31, capital C, to provide in the Constitution that no law giving effect to the policy of the state towards securing principles specified in clauses B and C of Article 39 shall be deemed to be void on the ground that it was inconsistent with or took away or abridged any of the rights conferred by Articles 14, 19, or 31. And lastly, the Constitution 29th Amendment Act 1972. It was an act which had added 2 small state enactments in the 9th schedule. Enactments, parts of which had been previously struck down by the High Court of Kerala, and even after the High Court decision had been upheld by the Supreme Court of India. I now come to part 4 of the lecture. The Supreme Court's response to this fresh batch of constitutional amendments was to refer all the challenges to these constitutional amendments, this time to a bench of 13 judges, to consider whether the majority decision in Golaknath was or was not correct. But the more important question before this bench was the true nature, extent, and ambit of the amending power in Article 368 of the Constitution. As one of the justices, Justice Y.V. Chandrachud, much later Chief Justice of India from February 78 to July 85, had written, and I quote, "The largest bench sat for the longest time to decide issues of grave moment, not only to the future of this country, but to the future of democracy itself," unquote. In Keshavananda, 1973, in the course of 11 separate judgments, 10 of the justices held that Golaknath was wrongly decided, since Article 13(2) did not place any limitation on the power of Parliament under Article 368 to amend fundamental rights. So Golaknath stood overruled by a near unanimity of all the justices, 12:1. The judges also said that the first part of Section 3 of the Constitution 25th Amendment Act 71 that had added original Article 31C was valid, with a majority of 7 justices out of 13 so holding. But that the second part of Article 31C, which said that, and I quote, "No law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy," was totally invalid because it excluded all judicial review, and thus it was in the teeth of the basic structure doctrine. A summary of the judgment of the special bench of 13 judges in Keshavananda was then issued after the judgment, which stated, amongst other things, and I quote, that Article 368 does not enable Parliament to alter the basic structure or framework of the Constitution. There you get the essence of your doctrine. 2 justices, Justices Palekar and Justice Y.V. Chandrachud, who did not agree with the views of the majority of 7 judges, and the 7 judges were Justices Sikri, Chief Justice Shenat, Grover, Hegde, Mukherjee, Reddy, and Khanna, also signed the summary acknowledging that it was in fact the majority view. However, 4 other judges, A.N. Ray, K.K. Matthew, M.H. Beg, S.N. Dwivedi, refused to sign the summary. This is a decision, you must remember, that really split the Supreme Court down the middle. The 4 other justices refused to sign the summary, a refusal which prompted some lawyers and academics at that time to opine that the summary did not and could not truly reflect the majority decision. But this is all useless, because in subsequent decisions of the Supreme Court of India, the summary of conclusions has been regarded as embodying accurately the conclusions arrived at by the majority. In Raghunath Ganpat Rao versus Union of India, which is AR 1993, Supreme Court 1267, in a unanimous Constitution Bench decision of 5 judges, the entire summary of conclusions had been reproduced verbatim as correctly recording what was decided in Keshavanand Bharati. In Keshavananda, 6 of the judges, Justices Ray, Palika, Matthew, Dwivedi, Beg, and Chandrachud, held that the power of amendment of the Constitution conferred by Article 368 was wide and unfettered, and that it reached every part and every provision of the Constitution, including the chapter on fundamental rights. But 6 others, Chief Justice Sikri, Justice Shalat, Grover, Hegde, Mukherjee, and Jagmohan Reddy, held that the power of amendment was limited. But these justices were not all agreed as to the extent of the limitation. It could therefore be said that the court was evenly divided. But the judgment that tilted the evenly divided view was that of Justice H.R. Khanna. Whilst construing Article 368, the power of Parliament to amend the Constitution, Justice Khanna and Keshavananda had clearly said, and I quote, although it is permissible under the power of amendment to effect changes, howsoever important, and to readapt the system to the requirement of changing conditions, it is not permissible to touch the foundations or to alter the basic institutional pattern, unquote. In his judgment, Justice Khanna had also said, subject to the retention of the basic structure or framework of the Constitution, I have no doubt that the power of amendment is plenary and will include within itself the power to add, alter, or repeal the various articles, including those relating to fundamental rights. This quote has been authoritatively regarded in a much later judgment of a Constitution bench of 9 judges of the Supreme Court in the year 2007 in I.R. Coelho's case as the majority view that was rendered by the majority decision of the bench of 13 judges. In Keshavananda, in reading implied limitation in the amending power, the Supreme Court had in this sense made new law. The narrow majority view in Keshavananda was criticized as an unwarranted assertion of naked political power in the guise of judicial interpretation. It was said that it upset the balance of power in the Constitution. By propounding the basic structure theory, the guardians of the Constitution, it was said, had at one bound become guardians over the Constitution. Constitutional adjudicators had assumed the role of constitutional governors. Was such criticism valid? Well, a great American judge and jurist, Justice Benjamin Cardozo of the US Supreme Court, way back in the year 1921, in his famous book, The Nature of the Judicial Process, had said, and you must listen to this, that the power to declare the law does carry with it the power and within limits the duty to make law when none exists. But then he had added, I do not mean to range myself with the jurists who seem to hold that in reality there is no law except the decision of the courts. The point is, and this is very important, the point is, this is Justice Cardozo speaking, the point is that the power of interpretation must be lodged somewhere. And the custom of the Constitution has lodged it in the judges. Just remember this. The point is that the power of interpretation of a constitution must be lodged somewhere. And the custom of the constitution has lodged it in the judges. Unquote. This, in my view, is the true rationale for the basic structure doctrine. If the narrow majority decision Keshavananda had stood alone, there may have been more and more critics of it. But it did not stand alone. It came to be questioned 2 years later. You must remember this also. Keshavananda was questioned 2 years later and was again affirmed in a unanimous decision of a bench of 5 justices. Let me explain to you this question. Since after the 1971 general election, with the Congress party having an overwhelming majority in parliament, India may well have moved into a state of grave constitutional crisis. But fortunately, the crisis was averted because, believe it or not, fate intervened in the form of a fortuitous event. On 12th June 1975, Prime Minister Indira Gandhi lost the election petition filed against her by Raj Narayan in the Allahabad High Court. Raj Narayan had contested against Mrs. Gandhi. He had been defeated in the 1971 elections from Rai Bareli in Uttar Pradesh. The extraordinary had happened. A prime minister in office who had been elected to parliament by a large majority had been unseated. And whilst her appeal in the Supreme Court was pending, an internal emergency was imposed on June 25th, 1975, with grave and ominous consequences. And in addition, to show the Indian public who was in charge and control, the Constitution 39th Amendment Bill 1975 was hastily and even more introduced and even more hastily moved by the government and passed by Parliament, all in 3 days in August of that fateful year, 1965, when Mrs. Gandhi's appeal was scheduled to be heard by the court. The power to amend the Constitution was invoked by the government virtually to strike out an appeal already listed for hearing for 12th August 1975 before a Constitution bench of the Supreme Court. Article 329 capital A had been added. You won't find it now in the books because it is gone. 329A had been added to the Constitution by the Constitution 39th Amendment Act. I have quoted clause 4 of Article 329A in a footnote in the written text of my lecture. And clause 4 of Article 329 capital A in effect provided, notwithstanding any judgment or order of any court, the election of Prime Minister Mrs. Indira Gandhi can never and would never be deemed to be invalid or void. It also went on to state that the judgment of 12th June 1975 of Justice Jagmohan Sinha of the Allahabad High Court, holding Mrs. Gandhi guilty of corrupt practice under the election laws, stood reversed, not by a pronouncement of a court, but by a constitutional amendment. This was in order to preempt the Supreme Court hearing and deciding Mrs. Gandhi's election appeal. However, and this is most important, the Supreme Court fortunately resisted this crude attempt. In Indira Gandhi versus Raj Narayan versus Indira Gandhi 1975, the bench of 5 judges relied for the first time after Keshavananda 1973 on the basic structure doctrine of the Constitution. And so it was that this decision, more than any other, helped to cement the basic structure theory and give it vital constitutional validity. In Indira Gandhi versus Raj Narayan, a constitution bench of the Supreme Court ultimately held that the judgment of the High Court of Allahabad was erroneous. Mrs. Gandhi's election was valid under the election laws of the land. But the court had to first hold and pronounce upon the validity of Article 329A(4). And the court first held, under the compulsion of a monstrous law, that free and fair elections were a fundamental part of the Constitution, so fundamental as to be beyond the reach of the amending power. The judges said that legislatively validating an invalid election under clause 4 and 5 of Article 329A without changing the law that made the election invalid would toll the death knell of the democratic structure of the Constitution, and that making an election immune from challenge and preventing questioning of the election before any forum, howsoever seriously improprieties and violation, was subversive of the principle of free and fair election in a democracy. This decision, therefore, constitutes, this is that Raj Narayan versus Indira Gandhi decision. This decision, therefore, constitutes, in my view, the high watermark in the assertion of the court's judicial power, a decision that was arrived at in the teeth of a very determined majoritarian regime. Later in the year 1980, it was fortified by the unanimous decision of a bench of 5 judges in Minerva Mills when clauses 4 and 5 were added to Article 368 by the Constitution 42nd Amendment Act. It was held to violate the basic structure of the Constitution, since it completely shut out all judicial review of any constitutional amendment, and in the opinion of the court, destroyed the identity of the Constitution. Then in 2007, the basic structure theory was finally reaffirmed unanimously by the bench decision of 9 judges in I.R. Coelho, which I've already referred to earlier. Always remember this: if the pernicious clauses of the Constitution 39th Amendment Act 1975 had been upheld, Indian democracy would not have been survived for long. One other thing you need to know: the basic structure doctrine, which had got established initially in the year 1973 in Keshavananda, with a very narrow majority in its favor, 7 judges in a bench of 13. It was then held by 7 judges that the basic features of a constitution could not be taken away by an amendment of the Constitution. However, 6 judges disagreed. You also may need to know something more important, which you may or may not know now, that there was a post-mortem on Keshavananda, 1973. And this took place in November 1975, where a bench of 13 judges was once again reconstituted by Chief Justice Ray to reconsider the correctness of the majority view expressed in Keshavananda. And on this bench of 13 judges, there were 8 new judges, all appointed after Keshavananda, 1973, replacing those who had retired at age 65, the constitutional age of retirement. And this bench of 13 judges, with 8 new judges appointed post-1973, heard arguments for 2 days on November 10th and November the 11th, 1975. It was Mr. Nani Palkiwala who appeared and argued the case at that time. But when the court of 13 judges reassembled at 11 a.m. on the morning of the 3rd successive day, 12th of November 1975, Chief Justice Ray, presiding over the 13-judge bench, suddenly and peremptorily announced, "This bench stands dissolved." This was only because Chief Justice Ray was satisfied that the doctrine of basic structure would not be reconsidered by any of his 12 colleagues. And this is now established. In his book, The Constitutional Law of India, 4th edition, volume 2, at page 1957, Mr. H.M. Sirvai, India's constitutional historian, has recorded the following about the post-mortem on Keshavananda. And this is what he said: the sequence of events would suggest that Chief Justice Ray realized before 10th November 1975 that his brother judges were not likely to depart from the theory of the basic structure. And it would also suggest that the 2 days hearing before the bench of 13 judges satisfied him that the doctrine of basic structure would not be reconsidered by the present bench, unquote. And you may also know that Mr. H.M. Silvey was not used to stating untruths. He was a very truthful person. And he was the person who had appeared for government, not against government. He had not appeared for the petitioners. He had appeared for the government along with the Attorney General in Keshavaranda. And what he reports in his book is not been refuted by anyone at any time because it is correct and accurate. This is not all. As already mentioned by me earlier, in the year 2007, the basic structure doctrine was once again questioned, and yet again a bench, this time of 9 justices, unanimously affirmed the doctrine in I.R. Coelho, AR 2007, Supreme Court 861. The basic structure theory was the response of an anxious and activist court to the experience of the working of India's constitution during the nation's first 25 years. You must know this, namely that constraints on constitutional amendments are attempts by courts, not just in India, but around the world as well, to ensure the survival of democratic institutions. I now come to part 5 of my lecture. In the past 50 years, 1973 to 2023, the application of the basic structure doctrine has the following pattern. Number 1, first, the doctrine of basic structure is now established and accepted not only in India, but by 8 nation states around the world: Bangladesh, Pakistan, Uganda, Israel, Malaysia, Turkey, Colombia in South America, and Belize in Central America. Second, let me give you how matters stand in India between 1973, when the doctrine was first enunciated, and 2023. Since 1950, we have had up to date 105 constitutional amendments, acts under Article 368. And only 2 days ago, the Constitution 106th Amendment Act was signed by the President, which was the Women's Reservation Bill. But we are concerned with 105 at the moment. Now, 60 new articles have been inserted in the Constitution by 105 constitutional amendments. 17 originally enacted articles have been removed, and 154 originally enacted articles have been substituted or amended. And third, since it is a self-imposed restraint, the basic structure doctrine has been held not to apply to ordinary laws enacted by Parliament or state legislatures, but only to constitutional amendments passed by Parliament. And fourth and most important, the basic structure doctrine has been invoked very sparingly by India's Supreme Court, as will be apparent from these figures, which I give you. Between 1973, the decision in Keshavananda, and the current year 2023, there have been 22 reported cases in which constitutional amendments have been challenged on the basic structure doctrine, out of which in only 7 reported cases, 7 in the last 50 years, and I have reproduced those 7 cases in my recent lecture. The challenge provisions have been struck down by the Supreme Court, struck down by invoking the basic structure doctrine. The 7 reported cases are noted in the text of my lecture in a footnote. In the remaining 15 reported cases, the challenge on the basic structure doctrine was repelled and rejected. That is to say, the validity of the challenged constitutional amendments were upheld, because the striking down was and has always been on some principle related to good judicial governance. What is the meaning of good judicial governance? One of the framers of the American Constitution, James Madison, had said in the Federalist Papers, and I quote, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary." In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the governance, and then the next place oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of taking auxiliary precautions. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of taking auxiliary precautions. And judicial review by the country's highest court is one such auxiliary precaution. In constitutional law, especially in constitutions that prevail in all the 56 Commonwealth countries across the world, governance is to be by all three organs of the state: the legislature, the executive, and the judiciary. And in matters of judicial governance, there exists a theory about its legitimacy, a theory that was expounded by a very renowned academic jurist of the 20th century, a man called Ronald Dworkin. Present-day judges, Dworkin had said, who may have had nothing to do with the written constitution when it was framed, by reason of their position as judges, have become and must act like partners with the framers of the constitution in an ongoing project, since it is and always will be an ongoing project, namely to interpret a historic document in the best possible light. To interpret a historic document in the best possible light. And he went on to say, and these are his words, not mine, judges must therefore sometimes make new law, either covertly or explicitly. But when they do so, they should act as deputy to the appropriate legislature, enacting the law that they suppose the legislature would enact if seized of the problem. This has since become known around the world as the Hercules technique of constitutional adjudication. Invocation of the Hercules technique of constitutional adjudication is warranted by India's constitution, because it is expressly incorporated in originally enacted Article 142 of the Constitution, an article that provides that in the exercise of its jurisdiction, the Supreme Court of India and the Supreme Court alone, not any other court, may pass such decree or order as is necessary for doing complete justice in any cause or matter pending before it. And the word complete justice is deliberately left undefined, leaving it to the Supreme Court and the Supreme Court alone to decide the case in the best possible light. The final part 6, reads like this. Finally, and most significantly, the basic structure doctrine or the essential features doctrine, which is its other name, has now acquired a place of permanence in constitutional adjudication simply because it had been initiated by India's parliament itself. And this is how it was done. Under Article 359 of the Constitution, as enacted in 1950, during a period when a proclamation of emergency is in operation because of internal emergency or external emergency, the president which in effect means the central government, is empowered by order to suspend the right to move any court for the enforcement of all or any of the rights conferred by Part 3. That is, all or any of the fundamental rights, even though in ordinary times, the enforcement of all or any fundamental right is guaranteed by Article 32 of the Constitution. So also during the period of an emergency, all proceedings in court for enforcement of fundamental rights, according to Article 359 as enacted, are to remain totally suspended for the period during which the proclamation of emergency is in force. But, and just note this, after the lifting of the oppressive internal emergency imposed on 26 June 1975, and after the 6th general election of March 1977, India's newly constituted parliament met and expressly declared by Section 40 of the Constitution 44th Amendment Act 1978 that the right to move any court for the enforcement of the rights conferred by Articles 20 and 21 of the Constitution can never be suspended, not even during the period when a proclamation of emergency is in force. To paraphrase this in legal language, it was considered view of India's parliament that the fundamental right to life and liberty in Articles 20 and 21 were a part of the basic structure of the Constitution. And in the statement of objects and reasons for this 44th Amendment 1978, it was expressly stated by the then government in office that this was done in order, and I quote, to check the misuse by the executive of this emergency provision. In other words, the right to life and liberty from then onwards had to remain a part of the basic structure of the Constitution. There is a postscript which I have put at the end. One more word at the end. There may be something to be said for the view that the basic structure doctrine is too vague unless it is defined. But the problem is it cannot be defined, since the nature of future amendments of the Constitution can never be predicted or divined. What if, not now, but later, some judges at their whim and fancy strike down an amendment of the Constitution which a special majority of 2/3 members of Parliament have approved? What is to prevent this from happening? What if a bench of 2 or 3 judges do not interpret the Constitution as may be amended by Parliament in future in the best possible light? There is a remedy. I would suggest the following. As a matter of practice, while it would be open to benches of 2 or 3 judges, as always, to reject challenges to future constitutional amendments, whole or in part, on the ground that such amendments violate the basic structure doctrine. As a safeguard and as a matter of regular practice, wherever benches of 2 or 3 judges are of the view that a particular future amendment of the Constitution in whole or in part violates the basic structure doctrine, that bench of 2 or 3 judges must refer the matter to the Chief Justice of India to constitute a special bench of 7 or 9 judges to determine whether the amendment so challenged, in the opinion of that larger bench, offends or violates the doctrine of basic structure. This would be a useful safeguard against any possible apprehended future haphazard action by smaller benches of 2 or 3 judges. Thank you very much. That's my lecture.
Thank you, sir. It was a pleasure to be a member of the NEETI forum to witness this day. With sir's permission, I now request Ms. Shashwati to take over the audience engagement section. So we have a set of questions we've received from YouTube link, which we've created. So with your permission, can we ask you those questions?
Yes, certainly.
Thank you, sir.
But how many, who are watching this? Who are hearing this?
So we've sent the link. It's playing live on YouTube.
I follow. But it is mainly your students.
Yes, sir.
I see. How many of them? You have
There are a lot. Right now in college, there are 700 students.
I see. Right. So
And
who
plus
are
it's sent
switch
to-
on here? I see. Good. Right.
Yes.
Yeah, go on.
A very good evening to all. Before advancing to the question and answer segment, I have to take a moment to express on behalf of all the viewers that your words have truly enlightened us. We've received a remarkable array of questions. Without any further ado, I am honored to present you a few questions among them. Firstly, being, how has the Indian basic structure doctrine affected or influenced the constitutional jurisprudence of other countries in the modern day, particularly?
But as I already mentioned in my paper, there are 8 different countries which have taken the view that this basic structure doctrine is the only way in which to prevent an assertion of power which is not democratic. That is to say, somebody imposing a particular thing on the rest of the people. So that's the only way. And therefore, if you read from all over the world, 8 different countries from all different continents of the world appear to have taken the same view, that a so-called wide power of amendment is not as wide as possible, but has to be interpreted according to democratic principles.
So I now request Shri to take over with her question.
Good evening, everyone. Good evening, sir. Your expertise and knowledge in the field of law is truly invaluable. My question is, what do you believe are the most pressing legal challenges that India is facing today, and what is your advice, or how can that be tackled?
That's exactly what I've said all along. If you read my paper, you'll come to the same, I'll answer your question. I can't repeat what is already said in the paper itself.
Thank you, sir.
So with your permission, I have a question as well.
Yes, go ahead.
What if Fali Sam Nariman was a judge?
Yeah. Yeah. It was, yes, exactly. If Fali Sam Nariman was a judge of the Supreme Court, as my son was a judge of the Supreme Court of India, it was Rohinton Nariman. Now, what if he came to the conclusion that a particular constitutional amendment passed by the requisite 2/3 majority of Parliament was contrary to the basic structure of the Constitution? What should he do? First, as a safeguard, this is what I mentioned right at the end. As a safeguard, he should, as a matter of practice, refer the matter to the Chief Justice for the constitution of a bench of 7 or 9 judges. Because please remember, it was a bench of 13 judges with a majority 6-5, 7-6, that had held originally the basic structure doctrine. This basic structure doctrine had been reaffirmed on 2 separate occasions. First, in the Indira Gandhi case, which I mentioned in 1965, and second, in the post-mortem of Keshavanand, where a fresh bench of 13 judges with 8 new judges on the bench hearing arguments for 2 days, and on the 3rd day the bench is dissolved, because the bench is also of the view that it does not require reconsideration. So what would be done by 2 judges or 3 judges or myself, if I were a judge, would be this, Therefore, it is the majority of judges who would have to take the view, because ultimately, as I already mentioned in the paper, the basic problem is that there has to be somebody who interprets a constitution, and that somebody has to be the country's highest court, nobody else.
Thank you, sir. JSS Law College Autonomous and the NEETI Forum is grateful to you, sir, for giving us an opportunity to host you and for interacting with the participants. I now request Mr. Antriksh to render the vote of thanks.
Thank you, Janak. Good evening, delegates, teachers, and team members. I am Antriksh Kodandara, and I consider it a pleasure and privilege proposing a vote of thanks on behalf of the NEETI Forum, JSS Law College Autonomous, Mysore. Shri Fali Sam Nariman, distinguished senior advocate, Supreme Court of India, former member of Parliament, Rajya Sabha, and formerly the Additional Solicitor General of India, interacting freely with the participants, made this day a truly insightful lecture to treasure. We offer our sincere thanks to you, sir. Any program works with the precision and poise, and all that is simply made possible by the vibrant and dynamic leadership of our Chief Executive, Professor K.S. Suresh. Our heartfelt thanks to you, sir. Our beloved principal, Dr. S. Nataraju, always gives us his valuable guidance and moral support in organizing events like this. And on behalf of the NEETI Forum, let me please offer our sincere thanks to you, sir. This success was only possible with the synergy created by our faculty coordinator, Pranav Nair, sir, and assistant professors, Ashay Chakraborty, sir, and Jagdish, sir, who constantly guided us with their total support, and thanks would be too little to offer. Kindly accept our heartfelt thanks. May I please thank Madhu Kumar, sir, for the flawless technical support. I offer my sincere gratitude to all the members on this committee for their dedicated involvement, cooperation, and managing things end to end. My final thank you to the audience for their disciplined presence, participating wholeheartedly, and making this webinar a success. Until the next learning initiative, stay safe, keep learning. Thank you all.
Thank you, Antriksh. Taking your leave for the day, I thank each and every one of you for being a part of this event and making it a fruitful one. Thank you, sir.
Sir. Thank you, sir. Welcome once again. Welcome to JSS Law College.
Thanks.
Thank you so much.